May it please your lordships. My lord, the petitioner has challenged the order by which the punishment of compulsory retirement from services has been imposed. That is in Annexure 6 at page 55.
Before commencing, whether your original application before the Central Administrative Tribunal
Yes,
was in time
yes, my lord.
within 1 year from the date of appellate authority's order.
My lord, that is in Annexure 8. The order is passed and
What is the date of appellate authority's order?
my lord, the date of appellate authority order is 31/7. Appellate authority. Your lord.
Appellate authority order.
Lord, that is 24/4/2009, your lordship.
What is the date of presentation of original application in the year 2010?
My lord, the OA was filed in the year 2010, your lordships.
Who is appearing for respondent? Ready?
My lord, the
What was the post held by the petitioner?
yes, your lordship.
What was the post held by the petitioner?
Yes, my lord. He was at the relevant time. He was posted as dealing clerk, postal assistant in the Department of Post. Dealing clerk.
Postal assistant?
Yes, your lordship. Same post. It is mentioned in the bracket postal assistant.
All right. What is the date of charge memo?
Date of your lordships?
Charge memo.
My lord. My lord, charge memo was served on date is 31/8/2005.
What is the date of your reply to charge memo?
Lordships. Not thereafter, my lord, the petitioner, after serving the memo of charge.
No, whether petitioner has filed his explanation.
Yes.
What is the date?
My lord, but before filing representation, certain documents were demanded, your lordships.
All right, you tell me. On what date you demanded documents?
Lordships. My lord, on 19/6/2006, the petitioner demanded 5 additional documents.
19/6/2006 or 2005?
19/6/2006.
Firstly, you asked for the documents on 23rd of December 2005 and then on 19/6/2006.
My lord, so far, what happened so far, the date of 23rd December 2005 is concerned, your lordships. What happened during the preliminary hearing of charge, the petitioner denied charges, your lordships. The petitioner was directed to submit list of additional documents and defense witnesses, your lordships. And 29/12/2005, the petitioner raised a protest against advice of the inquiry officer for removal of inherent lacuna in the memo of charge. There was certain lacuna in the memo of charge, and it was pointed by the inquiry officer.
Documents were supplied to you or not?
My lord, documents were only 2 documents were supplied, and the most important document that the charge is that the petitioner processed the bills with respect to the contractor and failed to follow.
Where is your explanation to the charge memo?
Lordships. Lord, that is 28/9/2007, Annexure 4 at page 31.
28/7/2007.
28/9/2007. Lordship.
What is the date of communication of charge memo to you?
Lord, Lord, the memo of charge was served on the petitioner on 1/9/2005.
The charge memo was served on
1/9/2005.
and you filed your reply on 28th of September 2007.
My lord, it was served, but the inquiry officer was not appointed. Your lordship, kindly see.
No, before appointment of inquiring officer, you are required to submit your explanation.
My lord, what
Then
happened?
only after disciplinary authority, after examining your explanation, then he will decide as to hold an inquiry or not. That is the rule position.
My lord, on 9/12/2005, the then additional director PC Patna subsequently promoted to as a chief postmaster Patna. He was appointed as inquiry officer, and the ASPO Vigilance Circle Office was appointed as presenting officer. They were appointed on 9/12/2005.
What is the date of inquiring officer's report?
Lordships?
Inquiring officer's report.
Yes.
And second show cause notice issued
Yeah,
to you.
no. The inquiry report date is 8/1/2008.
Your show cause notice?
So cause native was issued on 21/1/2008.
Your explanation?
Lord, reply to the second so cause notice was given on 13/2/2008.
13?
13th February 2008.
2008.
Lordship?
13 to 2008.
Yes, Your Lordship.
What is the punishment?
Well, the punishment, date of punishment by the disciplinary authority is 31/7/2008, and the punishment is for compulsory retirement from service.
31/7/2008.
Lordships. Thereafter, Your Lordships, the petitioner preferred appeal on 28/8/2008. The appeal was rejected on 24/4/2009.
What are the grounds alleged before the tribunal?
Lordships.
What are the contention taken before the tribunal?
You know, the contention, Your Lordships, is that the first contention was there was a violation of principle of natural justice. The
Violation of?
principle of natural justice, because the documents were demanded and the most relevant documents were not supplied to the prisoner, as a result of which the effective reply could not be given, and this has resulted in the miscarriage of justice, Your
Take the
Lordship.
charge memo dated 31/8/2005.
Charge memo,
Ah.
Lords. That is in Annexure 1, page 20. And the relevant portion, Annexure 1, Your Lordships, Article 1, page 22.
Take page 24. Which are the documents which are not supplied to you?
Lordships. My Lord, Annexure 2 at page 26 is my representation.
No, from this you point out, sir.
I have,
Annexure 3 is the list of documents.
My Lord,
Page 24. The inquiring officer has relied on these 7 documents.
then thereafter, Your Lordship, in order to give effective reply, I demanded additional documents from the disciplinary authority, Your Lordships.
You are not entitled for additional document.
My Lord, the
Whether you additional documents were taken into consideration by the inquiring authority in the inquiry proceedings.
no, my Lord, the first, the most important charge is, Your Lordship,
Sir, whatever it may be, sir, which document according to you that has been taken into consideration by the inquiring authority, and it is an extraneous document, then Annexure 3.
Yes. So far, the documents which has been relied by the disciplinary authority in
All these
support.
7 documents have given to you.
Just a minute. Yes, Your Lordship.
It has been given. Now, which document according to you, which has not been given with
My Lord.
reference to
Yes, my Lord.
Annexure 2 you point out.
Yes, my Lord. My Lord, the memo of charge as per the allegation is that I failed to follow the defined late departmental rules and procedures in processing the bills of the contract, Your Lordship. So, as per the memo of charge, it was the duty upon the disciplinary
All right, sir, show me which document.
Lordship, Lordship. My Lord, kindly see Annexure 2 at page 26. as directed in as directed in your cited later in regard to submission of additional documents, and the following additional documents and defense witnesses are essential to plead my case. Number one, the copies of the departmental rules and procedures relating to the processing the files by the dealing assistant for allotment of work and payment of bill to the contractors.
This has been cited by the enquiring officer.
Well, this has not been, but this is the memo of charge. This is the charge, Your Lordship. I failed to follow the department rules.
Sir, whatever the documents which are relied by the enquiring authority with reference to charge memo, list of documents, only those documents you are entitled, not beyond that. Since the enquiring authority has not taken note of these rules, departmental rules.
Since my Lordship, my contention was that there.
All right, we'll consider that is the issue.
No, it was not issued. It was not supplied
no,
to
it's all
me.
right. Correct. It is an extraneous document you are demanding, which is not relevant.
Lord, it was not in existence, Your Lordship. Therefore, it was not supplied.
Not existing.
This is the charge, Your Lordship. There was no late departmental rules and procedure in that department for processing the file. And the files were processed on the basis of dictation of the Assistant Director, Your Lordship. It has come in the inquiry report itself.
All right, show me from the enquiring officer report that which rule he has been taken note of.
Lordship. Lord, the inquiry report in extra 4/1 at page 46, Your Lordships. Your Lordship may turn to page 47, the second paragraph. The date for preliminary hearing was fixed on 23/12/2005. The charge official and the PO presenting official so and so attending the hearing. The charge was read and explained to the charge officials who denied it. The charge officials are asked by order sheet dated 23/12/2005 to submit list of additional documents and defense witnesses, if any. It was demanded by the department itself. And he was again reminded on 5/6/2006. The charge officer requisitioned 5 additional documents and furnished name of 4 defense witnesses. Out of the 5, 4 additional documents are allowed to be supplied, but only 2 additional documents were supplied to him on 26/6/2007 with information that the others are not readily available. Further, the written statement of Sri A.K. Eka and K.P. Sharma recorded during the departmental inquiry were requisitioned by the charge officer, which could not be supplied on submissions that the same are not available. The charge official nominated Sri so and so, not relevant. Now the Lord.
Sir, in the inquiry, the finding of the inquiring officer, which rule has been violated by you? Where is that finding?
There is no such finding, Your Lordships. Lord, kindly see. Contrary to that, it has come in the.
Then how the tribunal has considered?
Lord,
in which paragraph?
Tribunal has committed error of record, Your Lordship, that the petitioner admitted that the petitioner has violated the laid down rules and procedure. There is no such case of petitioner, my Lord.
Where, in which paragraph it is stated that you have admitted?
My Lord, kindly see. My Lord, the order of the CAT, Your Lordship, page 56, page 57, last
paragraph.
My Lord, there is no such paragraph, Your Lordship.
No, paragraphs are
first,
there.
The
paragraphs are there. The impugned order is
from the top.
17 January 2014. Page 60.
Lordships.
Sir, take page number 60.
Yes, yes, my Lord. Annex 8 at page 60, Your Lordship, is the order of the.
This is you are challenging, no?
My Lord. Para 5 at page 62, Your Lordships.
Read.
The last two lines.
Read the entire paragraph.
The discipline authority in para 3 of his order has categorically mentioned that the proper procedure was not followed in processing file for the awarding the contract to Harendra Singh, and the applicant recommended the rate quoted by Sir Harendra Singh contractor as lowest one, whereas no rate was mentioned in the note sheet. The prosecution witnesses, so also defense witnesses, have stated that the bill was prepared by the dealing assistant on the basis of measurement book.
Even the payment of the charge itself is not correct. Merely you can't say that constitution is violated. You must point out which article is violated.
Yes, who is for the respondent?
In this case, my lord,
Read
actually the matter was referred before CBI, my lord.
Whether CBI, ED, we are not concerned with
On
that.
advice of CGI, the departmental
Sir, we
proceeding
are not
is started.
concerned with whether
He has
CBI,
given.
ED. Please answer. Read the charge memo. What is the charge?
Annex 1, page 20, Lordships, the relevant portion, Annex 1, page 22, the articles of charge, Lordships. Page 22.
Read the charge number 1, sir. You don't have file.
Only counter is in my handed over.
Then
Only
I will
counter,
say,
my lord.
then we will pass an order.
My learned friend opinion in this case, my lord, just is a given only counter, my lord.
I can't help. We can't help. Yes, take down.
Correct, but they must point out which is the.
Yes, take down. In the instant petition, petitioner has assailed the order of the tribunal dated 17 January 2014, passed in OA number 53 of 2010. Passed by the Central Administrative Tribunal, Patna Bench, Patna. The petitioner was working with the respondent in the postal department as a postal assistant. He was subjected to disciplinary proceedings in framing article of charge on 31/8/2005, and it was communicated to the petitioner on 1/9/2005. The petitioner requested for certain documents before submission of his explanation to the charge memo. While Annexure 2, however, all the requested documents have not been supplied to the petitioner. Full stop. Thereafter, he had submitted his reply to the charge memo, and it was not satisfied by the disciplinary authority. Thus, proceeded to appoint inquiring officer and presenting officer to hold inquiry against the charge. Full stop. The inquiring officer had submitted his report on 8/1/2008. Thereafter, disciplinary authority issued a show cause notice on 21/8/2008 along with the inquiring officer's report seeking petitioner's reply/explanation. So the petitioner submitted explanation on 13/2008. Consequently, the disciplinary authority proceeded to impose compulsory retirement punishment on the petitioner on 31/7/2008. Feeling aggrieved and dissatisfied with the order of compulsory retirement dated 31/7/2008, he had preferred appeal before the appellate authority and it was rejected on 24/4/2009. Full stop. Still aggrieved by the order of the order of the disciplinary and appellate authorities, order dated 31/7/2008 and 24/4/2009 respectively, he preferred original application number 53 of 2010 before the tribunal. Full stop. Next paragraph. Tribunal on 17/1/2014 dismissed the petitioner's original application number 53 of 2010. Thus, the petitioner has presented this petition. Next paragraph. Non-counsel for the petitioner submitted that article of charge is very vague for the reasons that petitioner, while processing certain bills, has not followed the departmental rules and procedure, and it is not indicated in the article of charge which are the departmental rules and procedure. In fact, the petitioner had sought for those documents by annexure 2 to the inquiry to the disciplinary authority before inquiry was commenced. However, it was not supplied. The aforesaid in not furnishing the demanded documents with reference to the article of charge is in violation of principle of natural justice. The same has not been apprised by the disciplinary, appellate and appellate authority and tribunal. Full stop. It is further submitted that the inquiring officer has taken note of in his report relating to supply of demanded documents Thus, the petitioner has not been provided principle of natural justice to the extent that which are the departmental rules and procedures have not been followed by the petitioner while processing the bills. Per contra, non-counsel for the respondent resisted the contention of the petitioner and submitted that there is no infirmity in the disciplinary, appellate authorities and tribunals order. The petitioner has committed misdeeds as indicated in the charge memo, and it was proved in the inquiry. Thus, the petitioner has not made out a case so as to interfere with the orders, impugned orders to heard the land councils for their respective parties. Before adverting to the petitioner contention that he has not been provided principle of natural justice, he has not been provided opportunity in the inquiry, before the inquiry, and during the process of inquiry, in not providing departmental rules and procedure, which is the main alleged allegation against the petitioner, to the effect that he has violated rules, departmental rules and procedure in processing the bills. The charge memo reads as under. Is on page 22. Next paragraph. Statement of imputation of misconduct in support of article of charge, while annexure 2 to the charge memo, annexure dash Roman 2 to the charge memo is also charge memo do not reveal the relevant departmental rules and procedures which have not been taken note of by the petitioner while processing the bills of Gardinabad Post Office building and sub postmasters quarter located at quarter number 5, etc. In other words, statement of imputation is not supported by, article of charge is not supported by statement of imputation. In fact, the petitioner had demanded five documents, and he has been provided few documents except which are the departmental rules and procedure, which is the foundation for the foundation for framing article of charge against the petitioner. The aforesaid issue has not been apprised by the inquiring authority, disciplinary authority, appellate authority, and tribunal. Therefore, the petitioner has made out a prima facie case that he was not that the charge memo itself is very vague to the extent that petitioner did not follow the laid down departmental rules and procedures and process the bills as indicated in the article of charge. In other words, very vaguely the charges have been framed, very vaguely charge has been framed without indicating as to which of the departmental rule and procedure has been violated. In fact, not even a title of the departmental rules or procedures have been indicated in the article of charge and so also in the statement of imputation. Twist up. Therefore, findings of the inquiring officer and its confirmation by the disciplinary and appellate authority and tribunal are not in consonance with the principle of natural justice. Twist up. Apex court interfere in a departmental inquiry proceedings if the charges are vague. In the case of so and so, twist up. In the light of these facts and circumstances, the petitioner has made out a prima facie case so as to interfere with the impugned order dated so and so. Accordingly, stands set aside. In the result, compulsory retirement order dated 31/7/2008 and 24/4 and appellate authorities order dated 24/4/2009 are set aside. The petitioner is entitled to all service benefits. What is the age of the petitioner?
Lord, the date of retirement was 31/8/2016, Your Lordship.
Age of the petitioner.
Age, Your Lordships.
66. Because he retired in 2016.
The respondents are hereby directed to regulate the intervening period from the date of compulsory
68
retirement,
years.
that is 31/7/2008 till he attaining age of superannuation and retired from service. He is entitled to all increments and promotions if any. Further, monetary benefits shall be calculated by the concerned respondent and extend to the petitioner